Sundata, please start.
I would like to welcome everyone back to our second half of this session. And I am very pleased to welcome Professor Dr. Shantanu Kole, sir. Thank you, sir. And now I would like to give a little bit of introduction about Professor Dr. Shantanu Kole, our speaker for this session. He is a respected academician, researcher, and innovator in the field of computer science and engineering. Dr. Cook has earned his PhD in computer science from CSJM University, Kanpur in 2013. He currently serves as a professor in the Department of Computer Science and Engineering at Haldia Institute of Technology, West Bengal. He brings with him a rich academic career and over 18 years of dedicated research work. Over the years, he has authored and edited more than 70 publications, including research papers, book chapters, and books featuring in national and international journals and conferences. He has successfully filed numerous patents, with 17 patents granted to date. Contributed significantly to interdisciplinary innovation, collaborating across various engineering branches. We are truly honored to have him with us today. Sir, we now request you to take over and share your valuable insights with us. Thank you.
Is it visible to you, the PPT?
Yes, sir.
Okay. Okay. So thank you very much for calling me in your such a program, which is very nice to me, and I'm very honored here to by presenting here at RTCI 2025. I must congratulate HOD sir and all the respected teachers from IT department of Haldia Institute of Technology. Obviously, I'm a part of Haldia Institute of Technology. I'm a teacher from Computer Science and Engineering Department. And now we are going to start our session on IPR in academic research, protecting your innovations. Now, as we are going to start from the beginning, we first know
what is intellectual property.
First, we must know what is intellectual property. Do you know what is property? I think yes. If you have property, if you know about property, like your father's, whatever, if your father owned a building or a particular shop or anything, that is your property. That maybe your property or your father's property. Like I'm talking about the students. Now, the property which comes from your mind, that is comes from your intellectual things, that is called intellectual property. So there are two types of property. One is physical property, another is intellectual property. The physical property may be a car. A car is your property. But how to drive a car? That means we can say there is a particular software which you have made, or a particular process you have made, not exactly software, because software is not patentable, it is copyrightable, but though it is an intellectual property because it comes from your mind, your intellectual, your brain, from your brain. It's a child of your brain. That means intellectual property comes from your brain, and it may or may not have physical existence, right? So
intellectual property refers to creations of the mind, inventions, literary and artistic works and symbols, names, images, and designs used in commerce. Intellectual property is divided into two categories, industrial property and copyright. Industrial property includes inventions, trademarks, industrial designs, and geographic indications of source.
Like we can see,
Intellectual property refers to creations of the mind, inventions, literary and artistic works, and symbols, names, images, and designs used in commerce. Intellectual property is divided into two categories, industrial property and copyright. Industrial property includes inventions, trademarks, industrial designs, and geographic indications of source. Copyright includes
Okay.
literary and artistic works.
So as we can understand, as we can see in the presentation here, intellectual property is divided into two different parts. One is industrial property and one is copyright. Now, what is industrial property? Industrial property means your patents, your industrial design, graphical.
Sir, sorry to interrupt. I think your slides are not changing. We are still in the first slide, the title slide.
Oh. Now is it visible, the second slide?
Yes, sir, the second slide is visible.
What is intellectual property?
Now is the third slide is visible?
Property refers to creations of the mind, inventions,
No, sir, we are still on the second slide.
names, images, and designs used in commerce.
There may be some problem.
Sir, are you in the slideshow option?
Yes, I'm in the slideshow option.
Yes, sir. Then I think you need to share your full screen instead of just the PowerPoint screen. Otherwise, it won't show.
It is? Which option?
No, sir. I think you need to share your full screen instead of in the option, in the Google option, you can see you can share your full screen instead of just the PPT option.
Full screen option. Okay, that means the whole
Yes, sir. The entire.
entire computer would be visible.
Yes, sir. Yes.
Okay. Then I have to. Okay, let me off the screens. Now it is visible.
Yes, sir. We can see the second slide right now.
Okay. Now,
Yes, sir. Now we are on the third slide.
first slide or third slide?
No, third slide, sir. Yes, sir. I think it's working now.
Your voice is breaking. We are on the first slide, right?
Now it is on the first slide, sir.
Okay. Now second.
Second.
Now.
Yes, sir.
Now it's moving third.
Okay. Now it's okay, I think. Okay. We are starting from the beginning. So our topic is IPR in academic research, protecting your innovations. Now, what is intellectual property? This is the question we have in our mind. In case of property, there are two types of property. One is physical and another is intellectual property. Physical property, they have physical existence, but intellectual property, they comes from the brain. Now, intellectual property is divided into two different parts. First is industrial property and second one is copyright. In case of industrial property, it is divided into patents, industrial designs, graphical indications, trademarks, etc. In case of copyrights, the softwares, the written documents like books, etc. are copyrighted. You can see for Microsoft Corporation, it is written Microsoft Corporation C within bracket, then 2018 or 2024. That means up to 2008 or 2024, it is copyrighted. What is copyrighted? Microsoft products. If it is written Microsoft, then C, then a year. Similarly, there are books. Books are also copyrighted. If you write a book, then that will be, the copyright would be, if you go for copyright, it would be copyrighted from certain time period. In case of industrial property, there are patents. We are mainly going to discuss about patents today. But though there is first intellectual property rights, it is basically named as IPR, intellectual property rights. In case of intellectual property rights, the first part is patent. Patent means obviously, which is if you have invented something, that means your brainchild. If you have invented any technology which can be protected, which can not be used without your permission, then that should be patented. How it is done, the whole procedure I'm going to discuss in our next session. Now, there are trademarks. What is trademark? Trademark is basically a particular mark, a particular symbol that is being used to describe your business. Next is copyright. We have already discussed about copyright, like softwares, like books are copyrighted. Next is trade secret. Obviously, each and every business that is trade have their secrets, have their own secrets. Obviously, suppose if you have a restaurant, if you have any particular recipe which you did not want to disclose to all, like, there are McDonald's, like there are other organizations, KFC are there. They have their trade secrets. They have their own recipe which they cannot disclose to others. And obviously, if it is disclosed, you cannot use them for business. Why? Because they have registered their trade secret by the authority of that particular country. Now, in case of India, if your trade secret is registered under government of India, then obviously the trade secret cannot be used by any other organization if and only if they have the whole knowledge, though they cannot use, others cannot use, because if you have trade secret registered with the organization, the country, according to country rules and regulations. So these are called patents, trademarks, copyrights, and trade secrets. They are used in different ways for different organizations at different times. Now, we are mainly focusing on patents. Now, what is patent? Patent, we know, it's a creation of human mind which needs to be protected. The creation of human mind which needs to be protected. Now, what kind of invention can be protected? There are some particular inventions which can be protected. Not all the things can be protected by patent authorities or patent organizations. Any particular organization, any particular country have their own rules and regulations for protection, for inventions that to be protected. Now, an invention that must in general fulfill the following conditions for grant of patent. Now here I will discuss one more thing that is very important, that is grant of patent. Whenever you have gone through the whole process with a particular country's rules and regulations, you apply for patent, you must publish the patent into patent journals. I'm talking about Indian patent system. In case of Indian patent system, an invention that is first the whole documentation, the whole technical documentation with its diagrams, with its figures, with its everything you have to write in a proper way. Obviously, there is a proper format for that, and using that format, you have to write it in a paper, and it will be sent to Patent Authority of India. In case of India, the website, you can go for website. The website name is ipindia.gov.in. Using that website, you can register your patent. You can apply for patent first, and patent attorneys are there. They are the specified person who are LLB passed. That means law passed, and there is a 6 months course for that, special course for that, which they become patent attorney, and they will add non-technical part with your technical part. That means if you have invented some technology, your invention should be added with some forms. There are some form 1, form 2, form 3, up to form 9 are there. These different forms would be filled up by the patent attorney, and they are registered. They are sent for registration with ipindia.gov.in. Now, either this particular thing, your technical details will be accepted or rejected. It depends on Patent Authority of India. Now, if it is accepted, then it is published. Then it would be published through ipindia.gov.in, and it will be published onto journals, where journals of patent websites. Now, I'll show you how they look like. Now, after publication, there are certain things, there are certain questions they will ask you for, and you have to answer all the questions, all the queries, and everything. After that, the grant of patent is given. What is the meaning of grant? Grant of patent means, normally, whenever you have a grant, you can go for business. If you can use it for business purpose. Like if you have invented a particular technology in some particular way, in particular, suppose we are from computer science background, so we will say, suppose we have invented some machine learning technology with some network infrastructure. Then there are two parts. One is hardware, another is software. So obviously the hardware and software, both, we know, both hardware and software combinedly work for a particular technology. Now that particular process should be patented. If it is if the patent grant is given to you, then obviously you can sell your technology to some particular organization, which organization will use that your technology in a commercial way, and obviously for that you will get some benefits in terms of money. It may be in terms of money, it may be in some other ways. That will be depending between you, the techniques and the conditions signed between you and the company. Now, the which technology must be granted, which technology must go for patent, which will not. We are going to discuss that particular thing. A particular technology, it must be practical uses. That means if you are thinking about you will fly in the sky without aeroplane, now that particular thing may not be practical, because if you want to fly in the sky, obviously you must have some particular machine or some particular machinery or some particular technique by which you can fly. By your own hands and legs, you cannot. So obviously it is not practical. So you cannot ask for patent for this particular thing. Your particular product or your particular element must be novel one. It must be a new thing, and obviously, before I said, it has some practical use. If you have wings, if you have practical wings, like birds have, like if you have invented some wings, and by those wings you can fly in front of them, then it may be there may be some practical use. Now you have to show the element of novelty. Novelty means it must be new. Your technology must be new. There are lots of old technologies are there. You can use those technologies. By using all those technologies, you can use a new technology. That will be called as a novel technology. But if you have nothing new, or already old technology is there, and you are going for patent, obviously it will get rejected. So there are some new characteristics which is not known to the body of existing knowledge in its technical field. The body of the existing knowledge is called prior art. That means it should be a new one, and it must not be the invented by some other person. Now, The invention must show an inventive step. There must have some steps to follow. What steps? Means if you want to fly, then obviously you need some wings or you need some machinery to fly. Now there is helicopter to fly, there is aeroplane to fly, there are gas balloons to fly. Now if you want to invent some other technology to fly, then it must be an inventive step. Now what are the how to do with that, how to go with that, how to start with that? There must have some elaboration, and that elaboration must have some type of flow charts. Using those flow charts, you can go for some algorithm, and using those algorithms you can write any particular program so that you could do that. So there are hardwares, there may be softwares, and there may be the combination of hardwares and softwares. You could made some inventive steps. Not necessary the hardware should be there and software would be missing, or the software is there and hardware is missing. In case of software, if there is a particular software, then that cannot be patented, as I have already said, because software is not patentable item, it will be copyrighted item. So in case of hardware and software both, or any particular technology, the steps of technology, it can be patented. Now a person with average knowledge of technical field, that cannot be done. That means the inventive steps must be there from start to beginning. Start to ending. Finally, the subject matter must be accepted as patentable under law. That means you must not invent something which is unlawful. Obviously, if you are inventing a particular matter by which you have made a software by which you can take all the money from all the banks into your account, that is unlawful. So that cannot be patentable. So you must have these things in your mind whenever you are doing something which must be lawful. Unlawful things must not be protected by any organization, any country. Now, what is in case of IPR? There is a contract with the government. What is the contract? Contract, basically the contract is signed between the government and you, where government have certain rules and regulations, predetermined rules and regulations, which you give the public an invention and they have never seen it before. So if it is so, then it can be patented. And the government give you the limited monopoly. Limited monopoly means you cannot do everything with your invention. Now, as we know, there was a war was going on between India and Pakistan. Now you have invented some deadly weapon and you want to give that to Pakistan, then it not be good for you, and government may not allow that because the enemy country cannot get the benefits of our technology. So limited monopoly would be there. Government gives you permission to make the business, but not unlawful business or not for the sake of others country. Yes, for goodness of your country, for goodness of yourself, everything is good. It must be lawful and it must protect the environment, etc. There are different laws are there to protect everything. There must not be anything which is affecting our country, our people, our men, etc. Now, who grant patents? Now, there are different patent organizations in different countries. In case of India, we have National Patent Office. In National Patent Office, the regional office that does work for a number of countries, such as in case of India, there is a patent office in Kolkata, Chennai, Mumbai, and New Delhi. And you can see in the here in the PowerPoint presentation slide the address, phone number, and email of Indian, means Kolkata office. And obviously, beside Kolkata office, there are European Patent Office, African Regional Industry Property Organization, and under such regional systems, an applicant requests protection for the invention in one or more countries, and each country decides as to whether the offer patent protection within its borders. That means there are different countries are there to gives you patent rights. That means a particular technology which is patented in India cannot be same for European or for African countries, because they have their own organization, they have their own patent agency, their country have different rules and regulations. So if a particular product is patented in India, that may not for European also. You have to file another patent for the same technology in European. And these patent office may decide by their own rules and regulations whether it will be patented or not. It does not mean if it is patented in India, other countries will give you that. Other countries may or may not give you on the same technology. They may or may not give you. Why? Because I have already discussed, there must have some laws, there must have some rules and regulations. And you know, all the countries have different rules and regulations on their own. There are different organizations, and they have different rules. They have we have different countries, and you know, there are different rules and regulations for different countries for a same particular thing. So for same particular thing, the in Indian Penal Code says something else, and some others, European or American or any other countries, like in case of Middle East countries, they have different rules on that. So you must not sure that your product may be patented or not for same organization or different. Next we are going for WIPO. WIPO is World Intellectual Property Organization. The global forum, this is the global forum of intellectual property policy, services, information, and cooperation. Now, what is WIPO? Basically, this is administered Patent Cooperation Treaty, PCT, Patent Cooperation Treaty. It provides for the filing of single international patent application, which has the same effect as national application filed in the designated countries. As we were discussing that if we have submitted one patent in India, we have the same patent to be filled in case of European, in case of American, or in case of German, other countries. But if you file through WIPO, that means there are some cooperation treaties there. That means there are some common rules and regulations are there. If you file your patent through WIPO, then there is a particular patent have same value in all the countries who follows WIPO. It does not mean all the countries follow WIPO, but there are maximum countries, maximum good countries. I mean to say there are first and second generation countries, or the countries which are what can I say, developed countries. Yes, developed countries is the best world, developed countries, they all follow WIPO, Administered Patent Cooperation Treaty. That means if you submit your patent through WIPO, there is same effect in all the countries. Through WIPO, an applicant is seeking protection. It may file one application request protection in many signatory states as needed. That means once you have protection by WIPO, you have the same benefits in all other countries. Now the thing is patentable subject matter. Which is patented, which can be patented, which cannot be patented. We must have some particular idea on that. That is patentable subject matter. What is patentable subject matter? Anything which is man-made. Anything which is man-made, that is patentable. Like we can see here, there is a bulb, there is a TV, there is a laptop. These are man-made things. So man-made things are patentable. Obviously, they follow some technology. We know there is filament technology which is now converted to LED technologies. The TV, we are seeing the old TV, that is cathode ray tube technology, and now what we see, there are LED or LCD technology. So obviously all the technologies are different in nature, and these technologies can be protected by using patent authorities of different countries or through the WIPO. And obviously there is laptop. We know previously there were laptops in different countries in different ways, but today they have different technologies. We know there were i3 laptops are there, i7 is there, i5 is there. Again, there are different technologies. They have different companies, they made their laptops. So in case of technology changes, you have to, every time you have to file patent for your own technology to protect it. Otherwise, others can use your technology without paying something else. Now, we know Acharya Jagadish Chandra Bose, who was the inventor of radio. But obviously, he has not patented on that time. That was a time of English period, and there was not so easy. Today we have internet, and we can, by a single click, we can apply for patents in ipindia.gov.in. But obviously, on that time, that website were not there, and that patent authority, that India were in British rule, so that facility was not there. And the Italian scientist, he has patented that technology, and the name of Jagadish Chandra Bose, Acharya Jagadish Chandra Bose, the respected Acharya Jagadish Chandra Bose, his name is nowhere. But we know he was the first person who have invented the radio. That was a bad luck from our side. But today we can go for the articles of manufacture. That means the patentable subject matter. As we can see, there is a typewriter, or there may be the lenses of camera. Camera is patentable, and obviously the lens is again patentable, because you know there are different types of lenses in different cameras, and there are focal, depending upon focal points, and there are the particular things they have used, the material they have used. According to those, it can be patented, and it may be or may not be patented. Now, there are different designs are there which is patented. Like we can see, there are shoes from Adidas, there are shoes from Nike, there are shoes from Puma, there are other companies are there. They have patented their own design, and that design cannot be copied by other organizations. If they will be prosecuted. And obviously, we can see there is a Walt Disney cartoon, that is Mickey Mouse. This Mickey, the design of Mickey is again patented. That's why any other organization cannot copy that Mickey Mouse. Similarly, we know there are different other cartoon characters are there. Those are the designs. Those designs are patented, and if it is not, then somebody else can copy it and do their business by their own. Now, again, there is an important thing. I said there is a very important thing. This particular thing you should remember, or actually we all should remember. The process or method is patentable. Like there is a satellite. We can see there is a satellite, and there is a water system, water purifier system. These two process. There are different processes for different satellites. There are different processes by which the water can be purified. These processes or methods are also patented. Now, there are different, if you are using different technologies to purify the water, that can be patented. Now, the thing is that whenever you have different softwares, you are using a particular software or you have developed a software, what is the main thing here? If you have not completed the software yet, and obviously, to make a software, as you all are computer science students, to make a software, there are huge time is required. But before that time consumption, or when you are using that particular time, any other person can copy your product. So for that, if to get rid of that particular copying, what you should do? You should patent the process by which you are making the software. Obviously, we know whenever there is a software, before making the software, there are algorithms are there are flowcharts to be made for that. So the algorithms written in a particular method, and that method should be patented first. Whenever you discover a particular method by which you are going to make a particular software, you should patent it accordingly, and then you go for making that software. Because for making a particular software, you must take some time. It may be a big software may take time from 1 to 2 years also. So within that time, if somebody copies your technology, your process, or your method, then you will be nowhere. So obviously, it is better to protect it through process, or that particular process or the method should be protected through patents by making it patentable. If it is patentable, then it should be patented. Now, patentable subject matter. There are, in case of patentable subject matter, the composition of matter and the business methods, that should be patentable. What is the composition of matter? I'll after this lecture, after this PPT, I'll show you one example where the composition of matter is there. Means if there is some technology, those technologies are already there, but the composition you made in some way that that particular thing is something good or great, or have some particular output it is giving, that is novel, that could be also protected by patent. Now, there are business methods. There are different business methods. A few years ago, there was Geo SIM used to came. For first 6 months to 1 year, we get it free. They have freed everything, and what we did, we all changed our SIM and we all converted to Geo. Then what happened? Then gradually, they all the other players, like there are all other SIMs were there. Those companies were vanished from market, and they have got their monopoly. And after that, they have raised their fees. That means the first of all, it was free. then it was, I think, 399 rupees, then it is 599 rupees, now it is 799 rupees. So gradually they are make it what could I say? It is increasing every time. So obviously it is a business method. Using this business method, they have the market leader. They are the market leader right now in electronics and telecommunication market. So whether it is good or bad, the technology, the business method is there, and they have patented it, and nobody could say it's a method why you have taken or why you did this, or somebody else cannot copy that method if they have patented. I don't know they did it or not, but this type of method can be done. Now the thing is that non-patentable subject matter. There are these particular things, that is mathematical formula or algorithms, naturally occurred organisms, laws of nature, abstract ideas, natural phenomenon. These are non-patentable subject matters. These things cannot be patented. Now we'll move towards patenting procedure. Now, this is an overview of the Indian patent procedure, where a filing of patent application, publication of that application, examination of the application, objections, respond to office action by the applicant, then pre-grant opposition, hearing, if it is required, then obviously it is taken, and pre-grant opposition, if there is opposition is there, that suppose you have invented one technology and some other person is saying, no, this is our technology, not by yours, then obviously this particular thing should be there. And there are grant or rejection of patents. Obviously every thing which is sent for patenting, each and everything cannot be granted. There are some rejections also. There are post-grant opposition may be there. Obviously, if you get grant and on that time, if that particular person does not know about it, after grant, they can also oppose, and they could ask for any particular opposition. That means your technology, which is not yours, if they can prove, then obviously that should be the granted patent should be non-granted or rejected also. There are renewals of patents, but normally in case of means computer science, renewal is not there, because in case of ours, computer science is a very fast growing technical changes are there. Within 3 to 5 years, we get a new technology every time. We can see whenever we have started our journey in computer science, obviously on that time the technology was miles away from this particular time, and we believe after 5 to 10 years the technology will completely change. And the restoration of patents, if you want to restore it, obviously you can do that in case of Indian patents. Now the patent grant procedure, we are going to discuss about patent grant procedure. Now the filing of patent application is there. First we have to file the patent application. Then there are two parts. First is early publication and another is publication after 18 months. That means if we go for early publication, then within 60 to 120 days it will be published. In case of sometimes we could see within 10 days also we could get the result, and sometimes it may take 120 days. Obviously it's a government procedure, so we cannot tell what would be there. But in case of normal procedure, the publication is after 18 months. And there are pre-grant opposition is there, if any. It is representation by any person which is who knows that you are doing the same thing and who is doing the same particular technology they are working. They may oppose you. In those cases, patent grant is not there. and there is request for examination. The Patent Authority of India, they request for examination, and you have to appear before there. There are Mumbai, Chennai, Kolkata, and Mumbai, Chennai, Kolkata, and Delhi. There are 4 offices are there. They could call anywhere. Obviously, if you are from, like I also applied for some patents, and as I am from Kolkata, they are not exactly call me in Kolkata office, because they know I may have some friends at Kolkata office. So obviously they used to call normally. What I see, normally they would like to call me at Delhi or Chennai or Mumbai, but never in Kolkata. So obviously it's a procedure of Indian system, and I think it is good also, because I may have some friend over there where I could do something for my particular project. So publication of grant of patent would be there, and then post grant opposition, as we have already discussed. Post grant opposition to grant of the patent means after grant, if there is opposition, they can oppose. Everybody can oppose your patent that it is not yours. You can you have copied from somewhere else, or my work is copied by you. Such type of things could be there. It depends on your opposition, what technology you are working, etc. So now the types of patent applications we'll discuss. Like there are 2 different procedures we have already said. One is ordinary application, the application with provisional specification, and application with complete specification. That means if you are asking for provisional specification, not every detail should be given. All details are not given here. In case of complete specification, the whole details should be presented. And the conventional application, in case of conventional application, I said there is 18 months of time is required. And in case of PCT, as we have discussed the WIPO standard, if we want to go for WIPO standard, then in case of normal, ordinary, and conventional applications, WIPO, that means WIPO is not applied. That is, if in case of ordinary and conventional applications, only Indian system of patents would be there. That means your patent, you can make a business in India only. In case of PCT, you can go for other countries, like any country on their list. Obviously, they can you can go for that. That is PCT. That is international application. But normally people go for Indian application, not international. After Indian application is accepted, they go for others. Or if somebody have their own idea to business. Now, filing of patent applications are provisional and complete, as we have discussed. Now, provisional application of patent can be filed at the patent office to claim priority, and the complete specification has to be filed within 12 months from the date of filing of the provisional application. That means if we file today, that is today is 17th of May 2025, that means within 16th of May 2026, you have to complete specification you have to given. So in case of this application, 1,000 rupees is the fees for individuals, and 4,000 is the for normal non-individuals. Now there are different fees are there, as I have already discussed. There are early publication fees, there are examination request fees, there are application fees, there are different types of fees are there every time. Every fee is not given here, because I think this is not important. Only the government fees are discussed here. Next is publication of the patent. As we know, in case of normal applications, the patent application which is published by the Patent Authority of India at patent office journal, it takes time 18 months in normal procedure from the date of filing. Now, filing of a patent application in India, first, in case of natural person, the filing of patent application on Form 1 should be given, and the fees for the person, means per person, is 1,000, or in case of other organizations or other person, that is 4,000 rupees. And there is pro specification. There are filing of complete, the complete filing. If we go for normal filing, the filing should be completed within 12 months of the after provisional filing, and there are early publication would be there. If there is early publication, then 60 to 120 days time would be taken in case of complete specification. And there are different fees are there, as we have discussed. And after that, if FER is issued, that is first examination report, and if FER is issued, you have to go to the Patent Authority of India. They will ask the question, they will request for examination, and you have to appear before examination. You have to pass the examination. You have to convince them that your system is novel, completely novel. And if you cannot satisfy them properly, then your application would be abandoned. That means rejected. Otherwise, your examination would be, if it is successful, then it is published. That means your patent would be published. Now, this is the Indian grant certificate. This is the picture of Indian grant certificate. This is the sample. This is the Indian United Kingdom grant certificate. This is the South African grant certificate. This is the Japan grant certificate. Japanese are very clever. They used to go with their own language only. That's why you cannot understand a single thing. I think I personally, I don't know what is Japanese language. I don't know. So it is written in Japanese. Now, there are some sample patents. In case of ECE, actually, there were some people who have designed these type of patents, smart wearable cardiac anomaly detection using IoT and AI. Actually, we are working on these particular things. It combines ECG signal acquisition with on-device machine learning for early detection of arrhythmias. And there is second one is energy efficient Li-Fi communication module for indoor networks. It is visible light communication to transmit data with adaptive dimming control. And there is IoT based predictive maintenance system for industrial machines. This is the third one. So these are some sample patents we are basically working on. And finally, we have, if you want to work with me, you can call on my number, or this is my email. You can also email. And finally, thank you very much for calling me. And it was a very wonderful thing that you have called me. And finally, I have completed this. Thank you. And if you have any questions, you could ask me.
Participants, if you have any questions, please ask. I think, sir, there are no questions, so we can conclude the session. Before that, I would like to thank you very much for your time that you came here and you shared such a wonderful bit of information with us. And now I would like to call our head of the department, Professor Dr. Shomin Paul, words with us. Over to you, sir. Thank you.
Am I audible?
Yes, sir.
Yes, sir.
Good afternoon, everybody who are participating in this event. It's my honor to privilege to deliver the vote of thanks on this special occasion. On behalf of Department of Information Technology, HIT, I would like to express my heartfelt gratitude to all those who made this event a resounding and success. First and foremost, I extend our sincere thanks to our chief guest, Professor Asit Boron Maiti, Dean of Applied Science, Professor Radharani Das, Dean of Chemical Engineering, Biotechnology and Food Technology, for their taking time out of their busy schedule to grace us with their presence and share such valuable insights. Your words have truly inspired and enlightened us. Next, I would like to thank our speakers, the speakers of the first day of RTCI 2025, Mr. Ayush Sinha and Mr. Rajak Ahmed, for their speech over the area of mobile app development using Dart programming language. This is a wonderful hands-on application session using Dart Pad platform. Dart is a powerful programming language developed by Google, known for its simplicity, speed, and versatility. It combines familiar syntax with modern features, making it an ideal choice for mobile app development. Dart is used extensively in conjunction with the Flutter framework, which allows developers to create high-quality, native-like user interface for iOS and Android using a single code base. Next, I would like to thank Mr. Chiranjeev Mojumdar, conducted workshop over generative AI using IBM Granite with online coding practice that boosted our students and motivate our participants in the world of AI. IBM Granite is a family of open, performant, and trusted AI models designed for business applications. They are specially engineered to ensure trust and scalability in AI-driven applications. Granite models are trained on a variety of datasets, including those from the internet, academic publications, code datasets, and legal and financial documents. In our last session of RTCI 2025, I would like to extend my thanks to Professor Shantanu Kole, delivered his speech over the area IPR in context of academic research. Intellectual property rights, that is called IPR, are the legal rights granted to creators or inventors to protect their intellectual creation, such as inventions, discoveries, or creative works. These rights allow them to control how their work is used, copied, or distributed, and can be enforced through various legal mechanisms. Dr. Shantanu Kole discussed exclusively about IPR that can motivate our students moving for higher study, along with several inventions and challenging research. I extend my heartfelt gratitude to all the speakers for their engaging presentations and thoughtful perspectives. Your contributions have greatly enriched our understanding of the topic. A big thanks goes to our principal, Professor Torun Kanti Jana, our registrar, Dr. Ranjan Mishra, for their leadership and continuous support throughout the planning and execution of this event. We are equally grateful to our volunteers and support staff, anchors, whose behind the screen efforts ensured everything ran smoothly. To all the participants and attendees, thank you for your active involvement and enthusiastic response, your presence truly made the event worthwhile. Last but certainly not least, I thank the organizing team of RTCI 2025 for their efforts in handling the logistics and coverage of the event. Once again, thank you all for being with us today, yesterday, and today. We look forward to your continued support in the future. So, thank you. Have a great day ahead.
Thank you very much, sir, for your kind words. And with that, we come to the conclusion of RTCI 2025. I would also like to thank everyone, and we request the participants, please see the group for any further updates. Thank you, everyone. Have a good day.